This is Michael Cowen, and welcome to Trial Lawyer Nation.
You are the leader in the courtroom, and you want the jury to be looking to you for the answers.
When you figure out your theory, never deviate.
You want the facts to be consistent, complete, incredible.
The defense has no problem running out the clock. Delay is the friend of the defense.
It's tough to grow a firm by trying to hold on and micromanage.
You've got to front load a simple structure for jurors to be able to hold on to.
What types of creative things can we do as lawyers, even though we don't have a trial setting?
Whatever you've got to do to make it real, you've got to do to make it real. But the person who needs convincing is you.
Welcome to the award-winning podcast, Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowen.
Welcome to today's Trial Lawyer Nation. I am joined today by Przemek Lubecki, a great trial lawyer out of New Orleans, Louisiana. How are you doing today?
I'm great, Mike. Thanks for having me.
Well, thanks for coming on. Before we jump in, I want to thank our sponsor, LawPods. LawPods makes my life so easy. They're here recording our podcast for us. So all we have to do is talk to each other. They have all this beautiful lighting. If y'all want to come watch us on YouTube, you can see that we're really not that pretty.
Awesome.
But they have great lighting. They make it easy. They do all the editing. They make all the clips so we can put them on social media. So if you ever want to start your own podcast, which is a lot of fun, I highly recommend LawPods.
Fantastic.
Now that the bills are paid, tell me a little bit about yourself.
Well, so my name is Przemek Lubecki. I'm a trial lawyer practicing in New Orleans, sort of by way of Chicago, where I spent the beginning part of my career. I was born in Poland, came here as political refugees in 1989, from Poland, and then became a trial lawyer some way, somehow. The most American thing that I think anybody could do. So it's been a crazy journey, and it's the best job in the world.
So you started off in Chicago. I think I read that you got like some kind of recognition for trying more cases than anyone else in the state of Illinois one year.
Second most.
I'm sorry.
My buddy Tony Ellman was the plaintiff's lawyer, tries a ton of cases. But I worked at a firm in Chicago, Perillo, Weiss, O'Halloran, that tried the most cases as a firm in the entire state every single year of their existence. They just really got after it. And so I was lucky enough to get that experience, and I got sworn in on a Thursday, tried my first trial on a Friday.
Wow.
Yeah, first jury trial the day after I got sworn in, which we're like a dying breed, Mike, but it was an amazing experience in Chicago. I was extremely lucky to sort of just stumble into a firm that did that. My goal originally was to work at the DA's office to get that trial experience, but they actually had a hiring freeze, and by a weird set of circumstances, I ended up working for a firm that was the dream that I never even knew I could have had, really.
Yeah. That's actually nice to hear someone that does insurance defense work and calls it a dream. I mean, not everyone has that great of an experience, but it is good to know that, it's not always miserable on the other side.
So you know what? I think the thing that differentiated it from most other defense lawyers' experiences is that the people I work for were truly great trial lawyers, and they were really great mentors to me, which is why, when I look back at that experience, am I proud of every single trial I did and having sort of what my goal was to have a high kill ratio? Obviously not, right? Because my heart sort of isn't there right now. But looking back at it, I work with great people, and so that's kind of what I focus on as far as why I view it so positively.
So what did they do? You've been a lawyer for one day now. You're jumping in your first trial. What role did you have in that trial?
So all first chair jury trials. So I was thrown into trial, but not thrown in a sense without any mentorship. So I started there in the summer as I was getting ready for the bar exam. And we had, not only we would shadow lawyers who are on trial all the time, they would have, sessions for us. We had started as a group of like 7 or 8 people in a class, and they would teach us how to pick a jury. They would teach us how to cross-examine. They would teach us how to open. They would teach us sort of the bare bone structure of a burden of proof closing argument. And so it's not like we were thrown in without any support. And so even though the firm was very sort of aggressive about pursuing trials, they really did a great job building us up which gave us great confidence going in, even though we were, 25 years old, going against guys that were in their 50s and 60s trying cases.
That is so nice to hear, and so rare nowadays.
It is. It's my hobby horse, where I think the lack of mentorship in the law is a huge problem, because people aren't born trial lawyers. They become trial lawyers. And how can they become trial lawyers if they're not given the guidance, the tutelage, the confidence to do what we do, which is why I think part of the success of your podcast is that you are providing unbelievable value. I mean, I listen to every episode that you've ever done.
Oh, thank you.
You do tremendous work, not just giving people the sort of the nuts and bolts of what trucking entails, but I think people listening to you take away tremendous confidence from just hearing it done and hearing your story and hearing how you've been able to build your firm from scratch and how you've built yourself up into one of the most recognizable trial lawyers in the country.
So at some point you make a switch from being a Chicago defense lawyer to a New Orleans plaintiffs lawyer. That's a bit of a cultural shift.
It is. As I said to a judge when I first moved to Louisiana, I was helping somebody else originally pick a jury, and he told me, what does a Polak from Chicago know about a Cajun jury or whatever? And ultimately, I think if you have that human connection with people, people are people.
I agree.
And I really feel now that I could go almost anywhere and try a case because of that sort of having learned how to connect with people, having had enough reps to get comfortable on my feet in front of people. But you're right, though, that it was not an easy transition from defense to learning how to try a plaintiff's case. I struggled with that for a long time.
So before I get there, what inspired you to move from Chicago to New Orleans and from being a plaintiff's lawyer to a defense lawyer to a plaintiff's lawyer?
Yeah, so like every questionable decision in my life, Mike, a woman had something to do with it. But now in hindsight, with the benefit of hindsight, I mean, it was the best decision I had ever made. I am happily married, have a wonderful family with a different woman. But that was sort of the precipitating event for me, but it's like the most wonderful thing that's happened to me in my career.
It's funny, I went from big law in New York City back home to Brownsville, Texas to be a plaintiff's lawyer, a small firm, mainly because of a woman who was born in New Orleans.
How about that?
Who's now my wife. And
amazing.
We'll be married 25 years, so I guess it's worked out for me.
How about that? Yeah.
Hopefully it's worked out for her, but yeah. So you go there, and what made you want to switch sides? So I can see you fall in love with a woman. She's in New Orleans. You're in Chicago. That makes sense. But there are plenty of insurance defense firms in New Orleans.
There are. It was just one of those things that before I left Chicago, I had a friend of mine who was a plaintiff's lawyer. We would go up against a firm all the time, and he would always sort of, in a friendly way, rib me about the types of cases I was trying. I was trying, a lot of unoperated disc cases.
Yeah.
And it did not, once you sort of have the knack for it, you figure out how to do it. It doesn't take any great preparation or thought or imagination or creativity to try those cases. And so my friend Ben would call me the tallest midget in the courthouse. And so, I always aspired to learn how to be a better lawyer. And I knew that there was just so much more nuance and creativity and just how much harder it was to be a plaintiff's lawyer until I started doing it. And I realized, man, it is a lot harder than I even had anticipated.
So what did you do? You made the decision you're going to make the shift. And did you start right away with Morris Bart?
I did.
And so you're at a firm that gets a lot of cases, so you're going to have some opportunities to try cases.
Right.
What did you then do to get the skills you needed to make that shift from being an accomplished but kind of probably on script defense lawyer to being a good plaintiff's lawyer?
So the first case I tried in Louisiana, I essentially tried to reverse engineer on my own some of the concepts that I had learned as a defense lawyer. I mean, I knew how to pick a jury, right, in theory, but let's say my voir dire was mostly indoctrination.
Right.
It did not work on the plaintiff side to try to ingratiate and to try to indoctrinate, because people see us coming and we don't have much credibility in a courtroom at that point. So it was, while I got a verdict and it was a decent verdict, I was not satisfied with it. And so the first sort of paradigm shift for me was the reptile.
Okay.
And I went to a whole bunch of Don Keenan seminars, including a trucking seminar down in Destin, Florida.
Uh-huh.
And that is where my eyes were first open to sort of the breadth of how to present a plaintiff's case in general, not just trucking. It was just sort of in the context of trucking.
Yeah.
But that voir dire sort of opened my eyes. And since then, I've been coming to TLU and trying to learn from Sari and from other people as far as, different voir dire techniques to try to expand my repertoire.
Yeah.
And then still just trying cases and trying to rip it out.
So for our listeners that may not know, TLU is Trial Lawyers University. That's actually where we are in Huntington Beach,
Yes.
California today. And then Sari de la Motte, who's been on the podcast, I think 3 times.
Yeah.
And she's helped me a lot. Have you worked with her personally?
I have not worked with her personally, but I have heard every single episode of her podcast, and she leaves so much free milk out there that it's almost crazy.
Yeah.
And I've obviously read her book.
Well, I will tell you, the magic of Sari, the presentation stuff is really good, but the mindset stuff is what
That's
is
awesome.
even better. I'm actually in trial right now. We picked a jury on Wednesday. On Thursday, I did opening, put on the defendant truck driver and my trucking expert and my crash reconstructionist. We took Friday off. Right now it's Saturday. I'm going to go back in trial Monday. But I can do this because my mindset's like I'm ready. I don't need to.
I was going to say, don't let Mike's nice demeanor fool you. He has ice in his veins, apparently, because I could not do what he's doing right now if I was on trial.
Oh yeah, no, but because I'm ready. Also, I'm partners with Mallory Peacock, and so it's really easy to be in trial because she does a lot of work. But I just have to go talk to witnesses and talk to juries. It's easy. Doing all the motions and making all the arrangements and stuff, it's stressful.
It's very difficult.
But that mindset work makes a huge difference. But you've talked about applying some mindset or sports psychology concept to trial work. Can you tell me a little bit?
And so that's one of the things I taught at TLU this year and a couple other times is the things that I've learned from the world of sport. I used to box, do some Golden Gloves boxing when I was in Chicago, and I'm a competitive pistol shooter and rifle shooter. And so in that world, there's a gentleman, Lenny Basham, who is essentially the grandfather of sports psychology that now most champion level golfers and tennis players go to him for their sort of mental management. And so he teaches what performance looks like and the 3 spheres that performance lives in, and how we as lawyers, what I take out of that, we focus so much on the conscious mind, on the strategy aspect of trial, right? We're stuck essentially even up in, let's say, the days and weeks before trial in paralysis by analysis, trying to hyperanalyze our case as opposed to focusing on the performative skills aspect, having built up that sphere. But where, let's say, Sari and I agree 100%, is that sphere of confidence, which is actually what gives us access to our level of training. Because, pressure is an amplifier, and it's an amplifier of whatever emotional state we're in. So if we're in a highly anxious state, pressure is going to crush us.
Yeah.
Whereas if we're sort of in a state of arousal, we're excited, we have gratitude for what we're going to get from the jury, it pushes us into our subconscious mind, which is where all of our skill resides. And at that point, just like you're here, you're not worried about analyzing or still thinking about the strategy on your case. You're going to go back to trial and you're going to flow. Like you just said, I'm just going to talk to witnesses because that's your confidence that you're bringing into it. And so I think helping lawyers understand that gives them a sort of a paradigm or a structure around which to build out their practice, to think about how to improve each of those spheres, but to focus on what actually matters at trial.
And so what are the things you're doing to help lawyers focus on those spheres, try to get the, beyond just the analysis of the facts and into the being, I guess, in the zone is what I call it.
Yeah, so 2 things. We have to work on our skill set all the time because just like in the world of sport, there's no free speed on game day. And what happens when we overtry? Usually something falls off the rails, right? We have to sort of be at 100% and not try to be at 110. I can't overtry and do better. I just have to do essentially what it is that I'm doing. And the only way to do that is to build that skill throughout everyday practice. And so when I come to TLU, I teach with Dan. Dan's been kind enough to let me teach some of the skills boot camps where we focus on the physicality of the connection on voir dire, on openings, and on cross-exam. And so the lawyers that come to those sessions get essentially hundreds, if not thousands of reps, because we meet with them on Zoom beforehand, of a vehicle for learning the connection. The scripts don't really matter. What matters is learning them, focusing and putting your mind on the physical aspect of trial, the performative aspect, and then doing it so often that you get comfortable being uncomfortable in that moment of looking the juror in the eye and connecting with them and understanding them and hearing their story. And the juror knows that you're a real person, not just a lawyer who's trying to convince him of something.
Well, that connection is so important. I was doing my opening statement the day before yesterday, and I'd rehearsed it multiple times. And the first thing that happened is the way that I had rehearsed it, the judge would not let me put my flip chart where I wanted it, and she made me put it somewhere else. And then, like halfway through my opening, so that doesn't work anymore. I just stopped using it because I didn't want to move it and interrupt I have a 3-minute break in the middle of my opening. But the other thing I realized, so part of an important concept for the jury for this particular case is they need to know like 3 things about how air brakes work. They don't have to know everything, 3 basic things. And when I'd gotten almost all through my air brake section, I could tell by the look on their face they didn't get it yet. So I had to make an audible and go back on my opening and say, I don't think I've been clear enough. Let me go over this again.
Wow.
Because I just stayed on script. I said the right words, but I didn't. It doesn't matter whether it read well. It doesn't matter whether I think I did a good job. What matters is did they get it or not?
Right.
And whether that's them or me, it doesn't make a difference because the trial's about them. It's not about me.
Yes.
So I had to just call an audible and re-explain. I said, this is so important. Let me just go through it one more time because I don't know that I'm seeing the understanding between us. So let's just go. And then I saw nods, and then I moved to the next part, and then I had to leave another part out of my opening because I was splitting time with Mallory. But I knew that this was a critical part of the case, and I could tell because I could feel the connection. I could feel like, okay, I don't have them anymore. I need to bring them back.
You know what's wild about that is that I think 99% of lawyers, one, would miss it because their mental bandwidth is tied up in the words.
Yeah.
Right? They're trying to make sure that they stay on script. And they're not focusing, they don't have their finger on the pulse of what the jury is feeling. And I think the training that we're doing here, your mindset training with Sari, it frees up that bandwidth to actually focus on what is actually important. Again, that performative aspect. And by performative aspect, you're right, it's about the jury. But I learned something from you because you know what? There's probably been moments in trials where I have had the same realization, but I don't know that I had the courage at that moment in time to stop and to sort of say it another way. So
yeah, I think it's so important. One thing that I realized, earlier in my career, it would frustrate me because I'd try a case, I would lose, and then I had the jurors come up and ask for my business card. Oh, you were such a great lawyer and this and that. I'd much rather than say like, hey, you need to be a better lawyer after they get a big verdict, because that's what it's about them. It's about what they got. It's not about how good I looked.
Right.
And so when I realized it's not about me, so I can look a little awkward because I need to make it about them and make sure they're getting what they need. They're more important than I am. And then for them to trust me when they realize that them learning is more important than me looking good.
Right.
Then.
And I think I've tried to sort of figure out how to define a win for the jury so that they know what a win looks like for the plaintiff, because a lot of times, I've had those situations too where the jury is thinking that they're giving you a major victory, but really because of how the numbers shake out or whatever else happens, it's actually not a verdict that you and I, let's say, would be satisfied with.
Wouldn't go on the website.
Exactly. So yes, we're talking the same language.
So if somebody wants to learn from you and go to some of those workshops, do you have anything coming up?
So I'm going to be definitely in Vegas. The Vegas TLU conference is coming up in October.
Yep, I'll be there, I think, if I'm not in trial.
I'm certain you are, and I'm sure there's going to be a lot of great trucking content that you're going to bring with you.
Well, we'll find out. I got to talk to Dan about that, but I'll definitely, my body will be there.
Yeah.
And I'll try to stay awake on the stage this time.
Yeah, there's going to be so many people, I think. Everybody I've talked to, from the guys that were, where you and I met at ATAA in Atlanta, the trucking conference, to everybody that's heard you speak at TLU, everybody is so high on the content that you're delivering,
Well, thank you.
and also on the book. So I picked up your book in Atlanta, And I mean, you go over the nuts and bolts of building out a trucking case in that book. And I mean, that in itself is, I think, a must read for anybody who's interested in doing this type of work.
Thank you. But as far as the coaching, are they doing that small group coaching, actually performative stuff there at
Yes.
TLU in Vegas?
Yes.
Do you do it any other places?
So it's all up to Dan. He books it. He generally is running those boot camps in Vegas.
Okay.
So all those boot camp dates are available on the TLU website. So if anybody's interested, go to triallawyeruniversity.com. You can go online, figure out what dates work for you. If none of those dates work, you can call Dan and try to schedule training maybe at your firm if you have enough people who are willing to join, or you can have your Trial Lawyers Association in your state. Call him. I'm sure he's willing to travel. But just like what we did at the Paseo here in Huntington Beach, I got here on Saturday, 3 or 4 days before the conference actually started, and we did a 3-day boot camp of essentially 10 hours a day of doing voir dire, opening presentation skills, and cross-exam. And then I did 2 full days of teaching during the conference on essentially just a chunk of the presentation skills opening chunk for those guys that wanted to do that separately.
That is so awesome. And so glad you're taking a lot of time out of your real job that actually pays you money to do that too.
Yeah. But you know what? Honestly, teaching, as I'm sure you know too, because you teach so much all over the country, teaching makes us better lawyers.
Well, absolutely.
Yeah.
So are you able to help develop any of the lawyers at your firm too?
You know what? So in my firm, me and 2 other lawyers, Lauren and Abby, are the primary, seems like the trial attorneys at our office. That's something that I would love to implement. I have sort of a Friday session at Friday evening where I meet with lawyers in New Orleans and teach some of Dan's boot camp skills. And so we have a rough group of approximately 15 people. There's a core of 4 or 5 that typically show up any one time. And we work our way sort of in smaller chunks of the material. Yeah. But after a year and a half of doing it, I've got guys that have made tremendous progress, and they're going to be killers when they get into the courtroom just by putting in a little bit of work every week.
Yeah, that's so important. I mean, we do training every Friday, and we just got our courtroom in a few months, about a month ago.
Amazing.
It's so nice.
Yeah.
But yeah, I love trying cases, but I don't want to try 10 or 12 cases a year like I used to. I want to try it no less than 2, no more than 4. That's my sweet spot.
Yeah.
And so, but my law firm needs to try more than 4 cases a year. So I need to get my other lawyers all where they can all go try a case.
Right. And they all eventually need to have the same ice cold blood in your veins to be able to go and do it the way that you do it.
Well, unfortunately, to get that ice cold blood, you need to do 2 things more than once. You have to win.
Right.
You have to know you can do it. And you have to lose and live.
Yeah.
Because, a lot of the fear, it's like when you're in an airplane, the first few times there's really bad turbulence, it's scary as hell.
Right.
But then you realize after some point, I'm not going to die. I've done this before. I'm okay. And that time with trials now is like, I work really hard to be ready for trial. And I do everything I can to win the trial, but I don't worry about it because I have no control over whether I'm not in the jury room. I don't control whether I win or lose. I can have a greater chance of losing because I screw it up. I can have a greater chance of winning because I'm doing it right, but I don't control it, so I let it go.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. And now, back to the show.
So I love this conversation, Mike, because what you're saying fits exactly into that 3-sphere of performance model.
Yeah.
Because we have to stay at trial, we have to be process focused. We cannot think about the outcome because, again, the outcome is going to up our anxiety and is going to push us more into our conscious mind.
Right.
And so the only time I think that we can think about outcome is months or many weeks before the trial as motivation to do the work that it's going to take to win.
But you just do the work and you do it enough times, and sooner or later you'll win.
Yeah. But so I have not heard your airplane analogy before, but I'm going to steal it because I think it's such a apt analogy in the sense that you just have to sometimes just buckle down and get through it. But it's all ultimately about the stories that we tell ourselves about the performance that we had. So we can lose, but we just can't dwell on that negative. We have to apply the correction, figure out how to fix it, and be sort of positive coaches of ourselves.
Yeah, no, you want to learn from it, but I give myself 24 hours to mourn.
Yeah, I've heard you say that before,
and
I
you
think
have to go on to the next one because, let's say you're an NFL team and you lose one Sunday, it sucks,
Right.
but you got to be back in practice Monday morning because you got another game coming up, or you lose the Super Bowl. You think you're not going to try to win the next year. It's like, oh, I got to the Super Bowl, but I lost, so I'm just going to quit playing football. No, you go next year and you try even harder, and sooner or later it's going to be your year.
Yeah, I mean, hating losing is probably a mark of a great trial attorney.
Yeah.
And I have been gutted by losses before where you really love the client and you really want the best for them. So I don't know that I'm quite at 24 hours yet, but I'm working towards
I
it.
give myself permission to have 24 hours. I'm not saying that I don't have a little bitterness. Sometimes it flows through, but I'm really working on this is when you have permission, and after that, you just have to let it go. Hey, that case is gone.
Right.
There's nothing I can do. God gives me so much energy every day. I can spend that energy on things that I can do something positive with, or I can spend that energy dwelling on things that already happened.
I love it.
And,
I love it.
It's kind of like, sounds really mean, but like those of us who did not have a perfect childhood, it's like I can give those things the power to define my rest of my life, or I can say, okay, that sucked, and I'm going to go on.
Right.
I think it's the same thing with trial losses. It's
Right.
like, yeah, they suck. I'm not going to pretend like it's good. The only one that haunts me, and I was actually an associate, so I wasn't the decision maker, but we took a 0 verdict with $1.2 million on the table once on a very impoverished widow with 2 kids.
Wow.
That one still haunts me.
Yeah.
It wasn't my call. I would have taken it. But unless a client is, most of the time when you don't win a case, it's your ego, because the offers are almost always, the cases we end up trying, the offers suck. That's why we're trying. I mean, when they're offering our clients millions of dollars, usually they end up taking it.
Yeah, and a lot of times they make it easy for us, and at that point, the karma is all on our side of the case, which those are the easier cases to try.
Yeah.
The cases that are hard to try are when they're evaluating it, and you've got some issues in the case, and then you still have to go and try to deliver for your client. But again, I think you're 100% right as far as focusing on the positive correction of it.
Yep.
And just using maybe that bitterness or the sting or the being gutted by that loss as motivation.
But to me, it empowers me, because I know that, okay, I remember the first time I lost a case and I had $100,000 in expenses. I thought the world was going to, thought I was going to be broke, that nobody would ever refer me a case again, nobody would ever hire me again. And then like a month later, I'm still there and I'm not out of business. And a few months later, people were still sending me cases. And
something to be said about the man in the arena.
And you're like, hey, you realize like the worst happened and I'm still here. I don't have to fear the worst anymore.
Yeah. I mean, it's like that old man in the arena quote that ultimately everybody, including the other side, is going to respect the hell out of you if you go in there and you get after it and you give them a run for their money.
Yeah.
Win or lose, again, being process focused, and then learning from it and coming back again and doing it again.
And the more focused you're on what you're doing instead of the fear of winning or losing, the more likely you are to win, ironically.
Right. Yeah.
When you let go, and it just shows you're really uptight because you don't trust the jury.
Right.
I say, look, these are good people. I just tell myself, these are good people. They're here because they want to do the right thing. So I'm going to trust them to do it. I'm going to leave that to them.
Yeah. So in the voir dire training and the opening training, we give cues to sort of help people out with the physicality of whatever they're doing.
Yeah.
And one of those cues is that when you're looking around and you're connecting in the eyes with the jury, you have to like what you're seeing. And so your face has to communicate that to the jury. And so you have to have gratitude in your heart, or they're going to feel your anxiety. Absolutely. And they're going to feel uncomfortable. I mean, how many times do we, let's say, see a speaker who's anxious or who's nervous, and those mirror neurons, it makes us feel uncomfortable. Yeah. And so we never want to be in that situation with a jury. We want to be the leaders in the courtroom.
Yeah.
And the best way to do that is to be kind and to have true gratitude in our hearts for them being there to listen to our case and to stay and hear our case.
Also, when you tell the defense lawyer, like, isn't it awesome that we get to be here and do this? I mean,
That's
this is a blessing, and they don't usually feel that way.
Yeah.
And it freaks them out.
It does.
I'm always telling them, isn't this fun, man? I cannot believe that we get to do this for a living. This is so awesome.
Yeah.
And then, have fun, guys. And then they're just like, what?
Yeah. And so, again, I came from Poland. So for me, becoming a trial lawyer in America, an American trial lawyer is a dream.
You're
right?
one.
And so for me to be able to go in a courtroom, and I felt the same way when I was working, a lot of the cases I tried as a defense lawyer were the first however many I tried were property damage only cases to a 6-man jury, right? But I'm still getting the reps of talking to the jury, picking a jury, doing opening, crossing, closing, just getting those reps without a whole lot of anxiety because the cases don't matter that much, right? They matter to me. But when I look back and sort of in hindsight, I'm proud of that. It's I loved representing people. A lot of them at that time were Polish immigrants, Mexican immigrants in Chicago who had never really had anybody fight for them, even on a silly case, right? Or let's say they're defendants on a bodily injury case. Let's say there's a legitimate liability dispute. I loved representing the people. I didn't feel like I was representing the insurance company.
You're not supposed to be representing. You're supposed to be representing people.
Good correction there, Mike. Thanks for catching me here. But yeah, like representing those individuals is and having their voice be heard and sort of giving them a inkling of, hey, this is justice in America. You're going to have a lawyer who's going to go to town and try to defend you or try to prove your case. So that's why, again, I regard those experiences so positively in my mind.
Now, you've had a ton of, now you're on the plaintiff side, you've had a ton of great verdicts, 7-figure verdicts, even an 8-figure verdict. Anyone that you're really proud of you want to talk about?
Yeah, so my last trucking case that I tried, it had a punitive component. There was a driver driving for CEVA, a multinational logistics company, who was delivering a load of auto parts from Texas. He was delivering a load of auto parts from Texas to sort of the southeast Louisiana, and he had taken Xanax.
Oh my gosh!
And so, I got into the case about a month before the trial, figured out some of the FMCSA issues. I actually called Dan, and Dan put me in touch with a couple guys like Joe Freed and his partner Nathan Gaffney, and also Jay Vaughn, who helped me out with some of those concepts that, right off the bat, it wasn't apparent or clear to me as to what the rules really were, because, you can drive on an active prescription so long as it's within the load that you're prescribed and the medical examiner has blessed off on it.
If that's a big if with Xanax.
Right. And so in this instance, the driver had prior jobs where he was allowed to drive on Xanax by the medical examiner. He had lied on his application to CEVA, but CEVA, of course, had not done their due diligence in checking the prior employment records. He also had a deteriorating driving history with CEVA where they should have pulled him out of service. And so we were able to cobble together from all the depositions, essentially, a very sorry-like opening of a teaching section, the story of CEVA and what they did wrong that made the conduct and the ultimate crash foreseeable. Yeah. And so that was really the power in the case. I used a lot of the concepts I've learned here and I learned from following Sari as far as the voir dire and how I built that whole section out, figuring out how to voir dire on the punitive aspect of the case, the exemplary damages. And so for that, the only real creative ideas that I had on the case were to butcher paper 2 different boxes for the compensatory damages and for the punitive damages. And so how I voir dired on that is I drew on the left side of the paper, sort of just sketched it out. And I practiced doing it because I'm not the best artist. A windshield, sort of like a little trapezoid with a head. And I said, ladies and gentlemen, imagine a woman is driving down the road and there's a child standing on a bridge hurling rocks down below onto the highway. And then on the other side, I drew a poison bottle, like the skull crossbones in the poison bottle. And this is after I already fleshed out punishment. Why do we punish children? all the purposes for it, etc. And I said, do we only punish the child if the rock actually kills this woman? Or do we punish the conduct based on the propensity for the harm that may happen?
Right.
Because in my instance, the actual damages, the compensatory box wasn't all that big.
Mm-hmm.
But the punitive conduct was so reprehensible, both by the driver and by the company, for essentially having a loaded 80,000-pound missile drive through a school zone at 7:30 in the morning.
With the driver on drugs.
With the driver on drugs. And so the jury really coalesced around those two principles, and they all, to one, said, we punish the conduct. And they gave me all the reasons for why we punish: to prevent, to teach, to instill character in our children. But then I fleshed it out into how we punish companies. And so obviously money was a discussion that we had. And what was so powerful about that is that later on closing, when it came time to discuss those two boxes of damages, I reached into my briefcase and I unfurled that big butcher paper, rustling the paper around, and I didn't have to re-explain it.
Yeah.
Everybody knew because their memory was already indexed to that discussion on voir dire.
It also came from them, not you, which makes them, it's so much more persuasive to tell people they're right than to convince them you're right.
Yes. Yeah. It was that. And that was just a nice moment to sort of be able to open it up on voir dire and close on it, and for it to just feel good because we have such a righteous case.
Absolutely. Now, just because not all of our listeners will have worked with Sorry de la Motte or listened to Sorry de la Motte, so you talked about a teaching section and opening, because not like the traditional David Ball Reptile opening doesn't necessarily have a teaching section.
Right.
So what do you mean by a teaching section?
Well, so a teaching section is essentially a very sort of aspirational part of the case, where we, usually through 30B6 type corporate depositions, are able to establish what the rule set is as to what ought to happen.
Right.
In a safe company. What does a safe trucking company do? They do their due diligence before they hire the driver. They train them. They supervise them. They make sure that they're not involved in other crashes. If they are, they give them retraining. And so in this case, CEVA essentially screwed that up 8 ways from Sunday. Every which way they could, there was a red flag, which is part of the closing argument that I had put up on the board, where every single one of those infractions became a red flag for the jury that visually also let them know that this ought not have happened. Yep. And so later on, when you then describe as to what actually happened, the story of the case or the story of CEVA, the company, the jury is writing the rest of the story in their mind.
Absolutely.
Going, something terrible is going to happen. I don't know what it is quite yet, but it's going to be bad. And in this case, my favorite moment in the trial was an opening where we had the 911 tape of a driver who reported the truck speeding and swerving shortly before the crash. And so after the story of foreseeability, the story of what happened in this case stopped at the moment in time right before the crash, where I played the 911 tape. And I mean, I got goosebumps. You could hear a pin drop in the courtroom, and everybody was on the edge of their seats.
Yeah, they know what's happening.
Right.
And that's the great thing about the teaching section, is because you teach what should happen, and then you tell the story of why it didn't happen.
Right.
But you tell the story where they come to the conclusion on their own the defendant did wrong before you say the defendant did anything wrong.
Yeah, I'm not advocating at that point. You know?
And it's so much more powerful when they come to the conclusion on their own. And then when you say, they're like, oh, no shit, Sherlock. That's what you want. You want them to be almost annoyed, like, yeah, that's obvious. You don't need to tell me that. They did wrong. Come on, let's move on.
Yeah, it's the same way that, when I'm trying to teach my kids something, if I tell them something, maybe they believe me, maybe they don't. But if they experience it themselves, or I sort of lead them to the water, but they drink it themselves and they make it theirs, it's so much more powerful.
Absolutely. So how'd the trial turn out?
$12.5 million.
Oh my gosh.
Yeah, on $18,000 of past specials.
Wow.
So
a lot of lawyers would have settled that case for $36,000.
Yeah.
That is incredible. Well, that is just inspiring. It makes me want to go back to trial Monday.
Well, I take inspiration from you, so it's only fair, Mike, that I give you a little bit of a nudge too, from time to time.
Well, man, it's been so great talking to you. I could do it all day, but I got to get back to work.
Yes,
And you got to get back to the conference. So I look forward to seeing you at TLU in Vegas if I don't see you at ATA in September.
Right. I'll probably be there as well.
For everyone that hasn't signed up yet, I also have my Big Rig Bootcamp, July 12th in San Antonio, Texas. You can sign up at bigrigbootcamp.com. We're running out of spaces, so I hope to see you there.
And I've heard great things about your program. I've got a bunch of friends in Chicago that are going to Big Rig Bootcamp. So if I don't make it myself, I'll get some reports back from those guys.
Absolutely. Well, thank you all so much, and join us next time on Trial Lawyer Nation.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowen Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and commercial vehicle cases. If you have an injury case involving death or catastrophic injuries and would like to partner with our firm, please contact us by calling 210-941-1301 to discuss the case in detail and see where we can add value in a partnership. This podcast has been hosted by Michael Cowen and is not intended to, nor does it create the attorney-client privilege between our host, guest, and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.